Whether it is ourselves or the plaintiffs that bring the lawsuit, we need to act swiftly and surely in response to any suit that's brought. The attorney in these cases must move with speed and efficiency. Lengthy letters with snail mail can no longer be used. We must act with email, with fax, scan documents, use the technology we have to respond with new speed and aggression. Any salvos from the plaintiff must be dealt with swiftly and forcefully. Anything we get from them must be responded to and with more force. The discovery we send out must go out initially. The same fundamental discovery has been used for many years, but let's do it quickly and let's go for information that will help us to undermine their claims. Discovery such as interrogatories, requests for documents, requests for admissions. All of this goes, but it goes quickly. Conversely, we must define and limit the discovery that is propounded upon us by the plaintiffs. There has become this whole notion that just because a case involves a truck, that there is a thick set of discovery, regardless of what the facts are, regardless if the truck is moving or parked, but if it involves a truck, here are what we find and here's what we receive as the standard trucking interrogatories from the plaintiff side. No more. To the extent that they are entitled to information, we will provide it. But these blanket requests are too much and we must resist them and resist them surely. For example, where not otherwise warranted, the amount of logs that we should permit to be produced are 8 days, the maximum amount relevant under the 70-hour rule, period. Anything beyond that, without any other basis from the plaintiff, should be resisted. That is the type of drawing the line we should set forth to end or to at least stop the attempts of this blanket discovery, because it's a trucking case, without any relation to the facts of the case itself. Along those same lines, just as we get blanket discovery, we find that the complaints and actions that are filed in these cases are all too familiar. They bring a case against the driver and your company as the employer for the accident itself. But then tacked on to that is a boilerplate claim that your company was negligent for the hiring, training, supervision, entrustment of the driver, a number of claims that are in every case, regardless, again, of what the facts of that particular instance are. Many times these claims are sought to be used as a basis for punitive damages. We must act surely and swiftly in opposition to those claims. First, if it includes punitive damages, we want to focus discovery on those issues and get them dismissed early on in the absence of fact, to try to take the claim of punitives out of the case. If they don't include punitive damages, we want to move early on to have those claims dismissed, because there is a line of case law that supports our basis that they contribute nothing to this case. Think about it. The plaintiff claims he had damages as a result of this accident. If our driver caused the accident, our driver then ultimately could be responsible for those damages. And we as the employer be responsible for his actions. But those damages sought by the plaintiff as a result of the accident don't increase if there's additional counts of negligence, hiring, etc. after the fact. They're the same damages. They don't contribute anything to the action. Conversely, if our driver is not responsible for the accident, it doesn't matter if there was negligent hiring, entrustment, or any of the other litany that they bring. Because if we're not responsible for the accident, we're not responsible for any damages. These other claims are superfluous, they add nothing, and they should be dismissed early on.